Well, it's great to have Krista Clendenning with Traditional Law join us again for another video on estate planning and powers of attorney and just that whole area of law that is really important but doesn't often get enough attention. So, Krista, thanks so much for joining us today.
Happy to be here. Thanks for having me.
So, we're going to talk a little bit about powers of attorney, sort of the role of a power of attorney, some of the, like I said, the responsibilities, some things to think about when appointing an attorney. Really important area. I don't know that it was you that shared this with me, but I think your partner, John, at one point shared with me that one of the fastest growing areas of litigation was litigation against powers of attorney or attorneys defending themselves against litigation. And I think one of the reasons for that is that a lot of people, particularly in a situation where it's no longer a couple situation, now mom is widowed and her cognitive ability is not as good anymore. And now there's a power of attorney, could be a family member or a friend. But what happens is we get approached to act in this capacity as a power of attorney, and we're good-willed. And we put up our hand and we go, yeah, I can help you with that. And many times never done that before in our lives, have no real idea as to what the responsibilities are. And they're big and there is specific guidelines we should be following. And so we take this good-willed attitude in and start acting, not having any idea about how we should be acting. And before we know it, we're in a lot of trouble because we have not been fulfilling the responsibilities appropriately, and we're open to potential litigation from family or potentially other people in our circle. So that's why this particular conversation is so important. So I guess the first question I'd have for you is when we think about, just very generally, think about power of attorney typically or enduring power of attorney, where does that apply? Where do you typically see that discussion being really, really important in the context of estate planning and power of attorney planning for families? When they put that document in place, what are they thinking about? Why did they want to have that document there in the first place?
Yeah. So, in my view, power of attorney is just as essential as a will. And you could also argue maybe more important for you yourself, because this is actually who's going to be financially looking after you if you lose capacity or you're not able to look after yourself financially during your lifetime. Very important document. It is something that I talk to all my estate planning clients about. So, we're usually talking about wills, powers of attorney, which is the money management, if you're alive but incapacitated. And then if we talk about healthcare directives, which is the flip side with the medical or personal care decision making. If you putting it the key component, it's relevant for everyone. It is, of course, possible that you never end up needing your power of attorney if you have capacity every day of your life until you pass away. It's not a document you need, but it's a very good insurance policy to have in case something does happen. If you don't have a power of attorney and you lose capacity to manage your affairs, the fallback, no longer sign that document. You don't understand it, you don't have capacity to sign, is a court application. And those court applications, they're generally called a committee here in Manitoba, and that they're going to run you, I don't know, $5,000 or something to get an appointment done. You need medical evidence, doctors to sign affidavits and things. It's pretty comprehensive in comparison to a power of attorney, which, that standard power of attorney might be $300 or something with doing it with a will. So I think it's a good thing for everybody to have and essential for covering off looking after you and your assets and what they can do with your funds if you've lost capacity.
That kind of leads us into my first question here, which is relating to investment obligation with the power of attorney and the kind of the impact on the principal person's portfolio. So let's say they had a certain investment risk level while they're alive, right? And things change. How does the power of attorney kind of handle the shift in moving maybe from a higher risk portfolio to a lower risk portfolio, and how they should think about that?
Yeah, so a lot of attorneys are not aware of their investment obligations, and they have to be pretty conservative. The goal is preserve this money for the individual for their lifetime. We can't enter into anything too risky. And if you're taking over at a time when the individual's in more high risk investments, you should really be taking a careful look at that and shifting things and working with a financial advisor to help you with putting together an investment policy plan for how you're going to be investing in accordance with trustee rules. It's a trust investments. You're managing money and investing for the benefit of someone else, which just puts you under this fiduciary obligation to look after things. So there's a shift that does have to happen. And one of the other delicate things with powers of attorney is sometimes it's a slow shift to fully taking over the assets. Sometimes people step in and help mom or dad with some of the bill paying, but they still have capacity. And then they slowly take over more and more till it gets to a point where parent can no longer manage their money at all and they've fully had to take over. Somewhere in that transition, at whatever point we can kind of mark it as this was the date that the person no longer could manage their financial affairs, that's really the moment that your obligation shifts to making sure you're conservatively investing, making sure that you are paying and tracking everything on behalf of this individual. And you also have reporting obligations that arise as of that point as well.
What about, here's a question that came up the other day in talking to a client, is let's say that, I'm competent, I'm making my decisions. And part of what was really important to me on an ongoing basis was my regular contribution to the Winnipeg Foundation and making contributions to our ESP accounts for my grandchildren and making an annual donation every year, exactly the same amount to my church. And then I lose capacity. Does my power of attorney have the ability to continue with those gifts in the same fashion if I've lost capacity? Can they make that judgment call for me, or do I need to be thinking about those things when I'm drafting my power of attorney to give them that power?
Absolutely something you need to think about in advance and put into your power of attorney. So the starting point is if someone's lost capacity and the attorney's taken over and they're managing their financial affairs, there can be no gifts to anyone else, no gifts for Christmas, birthdays, charity, no support to other family members that they're not legally obligated already or contractually obligated to pay. So that is a discussion that you want to have with your estate planning lawyer, is to identify, is there gifting that's really important to you to continue even if you've lost capacity? And we usually want to be really specific with that, set limitations, talk about which group of family are we making gifts to, what's the maximum amount per gift, what are the regular charitable practices. Sometimes we include even a direction that says, look at the prior gifting pattern before I lost capacity, maybe for the last 5 years, and use that for some guidance. But you do want to be very specific.
You mentioned this earlier regarding attorneys and whether or not they know that there's a pretty important investment component to their decision making. Do you have any common mistakes that they make often concerning the principal's money?
So ones that come out of the cases, entering into a long-term real estate, like private real estate investment, something like that it's like, look, you're not getting the income back. It's risky. You don't, stuff gets locked up for a long time. So things like that. You can't.
But the potential returns could be huge.
Well, yeah. Oh my gosh. Yeah. Don't even start it.
Yeah.
No, yeah. You can't gamble with their money, right? Vegas, you could all go to Vegas and put it all on rent, but like not a good plan.
So what level of detail, you mentioned earlier, it's really important to keep track of everything you're doing and document everything. So what level of detail and documentation is legally required for the attorney when accounting for the principal's finances?
So generally speaking, you want to keep a summary of everything that's going in or out of their asset. So I find a lot of attorneys will, when they step in, they might consolidate funds as well, just to simplify affairs. It's also very difficult when people have funds in a million different financial institutions and you're trying to track all of that, because what the attorney is responsible for is tracking every expense that goes out of the donor, the person that's incapacitated, the donor's funds. So you've got to track every single payment out. You should be keeping receipts for things. If you have made a cash payment for something, for the snow removal guy, we want to make sure we get a receipt for that so we know what's happening with all the money. If you end up going through a passing of accounts, which any attorney might be required to do, it's usually required if you're seeking compensation for acting in your role as attorney in order to have it approved. The court will require a statement of funds received and funds dispersed for this individual's accounts for the period that you've been acting. So that's kind of the formal manner in which you'd hold the records. And then the court or a beneficiary or something could ask for a receipt for a particular amount. So you should be tracking all of those as well.
I had, again, your partner, John, I remember him talking about power of attorney rule and how sort of unclear it can be. It can be this very gradual thing. And over time, you eventually find that you're doing a lot. But you just kind of slide into it over time as mom or dad give up more and more of those day-to-day activities, particularly in the financial realm, obviously. He said, wouldn't it be great if they're like butterball turkeys? I said, what do you mean butterball turkeys? Yeah, like the minute you need to act as their power of attorney, it's like pop the little butterball turkey plug pops out of the turkey. It's ready in the oven. So same thing with mom and dad. I thought it was kind of funny because it's ambiguous. It's not clear. When we take a look at this responsibility, a couple of things have come up I've heard from clients. Number one, man, is this taking a lot of time?
Yeah.
Holy smokes. Like, although I have financial responsibility, I'm also taking them to medical appointments and they don't begrudge it, but they're just shocked that they didn't think through when they said yes, what this would do in terms of potential impact to their life. So a couple of things, and you may have some comments on this. When you think about the characteristics of who is a good power of attorney, that can look different, obviously, than an executor. You talked about executorship. You could literally be anywhere in Canada and probably look after the responsibilities as an executor. And it's a relative finite responsibility, right? It hopefully it's going to be done within a year, 2 years, 3 years, and that's done. But a power of attorney potentially could be something you're doing for an extended period of time, for a long time. And I want to know if you have any comments about things that you're doing with powers of attorney agreements around giving guidance to who's the best candidate, and secondly, or at least the qualities, and secondly, even the issue of compensation. I can imagine people taking time off from work. It has impact on their own financial lives. And do you see families building into those agreements some sort of compensation structure to make allowances for time off, just the inconvenience of it? Because I think that's a real conversation. There are going to come in, and maybe we just anticipate that if it's a family member, they're going to do it because that's what you do. But certainly if it's a non-family member, and I would apply it to family members as well, is compensation a reasonable expectation? So any comments about those two areas, qualities and compensation?
So I like to have a conversation about the trust with attorneys. And you brought up earlier in this conversation that this is a very litigious area now, that we're seeing a lot of case law about attorneys. And unfortunately, it is a very ripe area for abuse. If the wrong person's in that role, a power of attorney is generally an all access pass to your money and your assets, and the bank doesn't have to check that you've lost capacity necessarily. That document gets in. So every year I see a few of these myself, where someone's abused the document, someone takes money, and it's really hard. People doing that are generally not, it's hard to go track down the money and get it back once it's been spent. So trust of the person you're naming, whether it's a close family member or not, I have this conversation every time I'm signing a power of attorney. And I tell clients, if your trust in these people ever changes, I don't know if it's like a mental break, it's something else, you should circle back, worth us to re-sign this and do a new one. So that's a key one, as I say, trust. And then I think the accounting and who's acting, like that also plays a role. So sometimes just because of the administrative burden that this does put on the attorney, that they're doing all this stuff, working with all the financial institutions, paying all these bills, sometimes it bleeds into that personal role where they're driving people to appointments and things like that. Typically, we do see an individual appointed as an attorney. You could have multiple people appointed jointly, but each time you're making a decision, if you've got joint attorneys, they're actually both supposed to be at the bank confirming, both signing off on everything. So the administrative burden that creates, often people choose to just select one. And when we do that, then I like to have a discussion about who's going to be the recipient of this accounting every year. And maybe do we want that person to have a power to ask questions at any time, or, access financial information at any time to review what's going on here. And you could still appoint, we talk about U.S. resident people, like that U.S. resident person could still be the recipient of the accounting. We just don't like them acting in the attorney role because it creates issues on the tax side or other sides. So picking who that person is that's overseeing things, I think, is really important, as well as the actual person managing things on your behalf. And then to your point about compensation is a very important discussion for these roles. And the general rule is the attorney cannot receive compensation unless it's been explicitly authorized in the document. So I'm usually talking to clients about, is there, an amount that we want to put in there, a rate, an annual thing you're going to pay them. And there's other implications with that because it's taxable income to the individual. Depending on the amount that they're receiving, there could be CPP contributions that need to be made related to that income. So compensation can get a little bit more complicated than people expect. But the first question is it something you want to authorize or not? Do we want to open the door for that? And then even on the flip side of the money management, you mentioned personal care decisions and driving people to appointments. And that can be a whole other role that's not even necessarily directly related to the money management, the actual power of attorney role.
Yeah.
And so, yeah, we want to have a conversation with the family about, okay, if it's a different child doing all this personal stuff, do we want to authorize compensation for them as well? And if you're doing that, we probably need something that goes in both the healthcare directive and the power of attorney, that loops that all together. So it's something you definitely want to talk about, because if there's nothing built into the documents, the fallback is no compensation can be paid for these roles.
That's fascinating.
When you talk about that process, I would think if I was in a situation, I knew a little bit about the family dynamic, the more complex it gets, but even in straightforward situations, I'm just thinking, you know what, maybe it's a hassle to have joint power of attorney, but what a potentially good way of protecting yourself. Like if there's a countersign on every time you do something, there's this, right? And we do that in a lot of other areas of business and professional life, where you would never put yourself in a situation where there's not somebody looking over your shoulder or watching what you do. I watch what you do. We both sign off on it. There's protection for both of us.
Yeah.
So when you think about it from a protection standpoint, yeah, it's a hassle. It might be a very important part of your own risk management around these roles, particularly going forward with, like you said, all the litigation that's going on.
Yeah. I think unless, sorry, if you have something to add there, go ahead.
No, I was just saying I totally agree. Like, it's a balance I find with people, this administrative effort versus do we want multiple people keeping each other in check? And that balance just gets weighed differently for different people.
Yeah, for sure. All right. So the complex situation that attorneys have to navigate, one of the most common, I think, is shared properties and family cottages and all the responsibilities involved with that. So with a shared property like a family cottage, how does the attorney determine who is responsible for paying the ongoing expenses of that property when a parent becomes incapacitated?
Yeah, and this one's you've got to go get some advice, you've got to figure out what's going on for this family specifically. So is this a property that's solely owned by the parents and the intention is that it's being passed on to the kids through the will? If that's the case, maybe we want clarity in the power of attorney that even if I've lost capacity as the parent, that cottage can still be used by the family. You can still pay all the expenses, or there's an intention that there'd be some expense sharing. It'd be nice to have that dictated in the power of attorney, because the normal power of attorney role, if I'm looking after someone's affairs, I shouldn't be paying all the bills for an asset that someone else is benefiting from. I should probably just sell that property if they don't need it anymore. So I do think it's important to identify properties like that and the intentions around the expenses and how long we're holding it, and do we need to reference anything happening in the will? And then there's other arrangements where you might be joint owners, where tenants in common owners with the property. So you could have any kind of shared ownership. And then what's the breakdown of expenses? Do they have an arrangement with that? Is the intention that if I've lost capacity and I can't use the property, am I still expense sharing, or are you taking over the expenses? So I think it is very fact specific, but it's definitely something to identify and plan around.
Yeah. I think you mentioned this earlier, but asking a lawyer to help you with this is key. Asking a planner.
I think powers of attorney, people do not think to go get advice when they step in as an attorney, but they always do as an executor. And I think the trigger is the probate. They know they need probate. They know they need a lawyer's help with that. But power of attorney, there are so many dangerous steps you could accidentally take without knowing. And how would anyone know their legal obligations? Some of the stuff isn't even written into the power of attorney document itself. When we talk about the accounting obligation, that's something that's in our Powers of Attorney Act. It sometimes gets written into the power of attorney itself. I like to do that as my practice, but sometimes it's not there. So if I don't talk to a lawyer, I haven't dealt with this before, I would have no idea about that obligation.
What about another real world example, which would be if the incapacitated person was previously supporting a family member? Are there any specific authorizations that are required for the attorney to support or continue those payments?
Yeah, so I like to identify if there's family members, other people like that, the charity clauses we talked about too. Figure out who they're supporting, and if they lose capacity, is that something they intend to continue to do? Is it helping them out with rent? Is it just in case of a emergency, if one of the kids loses their job or there's a medical event or something? Identifying what situations they want to provide support for. I do a lot of work for families that are planning for kids with intellectual disabilities and supporting them even when they're on government support. And you have to be very careful about how you're supporting them and the language that you use. It has to be totally discretionary in those cases. So we have to look at like who the person is, what type of support are we providing them, what other rules might we be navigating, and make sure that anything if we want any money paid to a beneficiary while the person's alive, to support them during my incapacity, that's got to be written into the power of attorney document itself.
Krista, thanks so much for helping us unpack this really important part of estate planning, powers of attorney. And it's a bit of a landmine. And so I guess the takeaway is planning and getting professional advice. So again, for those of you that want more information about Krista, you'll find it in the notes section below the video. And again, thanks, Krista. We look forward to our next conversation.
Great. Thanks for
And
having me.
one more thing. If you're watching, you have questions to ask, or you have questions for Shaun and I, make sure you comment them down below. And that's all. Take
Perfect.
care.
Absolutely.
Bye-bye.